हेलो। हाँ मैं समझ गया, समझ गया। वो कर दूंगा पहले हो गया ना। हेलो। हाँ आइए गाना। अच्छा सर नहीं ये नहीं, ये तो अपने को बना तो उसका इलाज कर। सबको एडिट करूं। आइए गाना।
हो गया कनेक्शन। गुड आफ्टरनून सर। बेटर सर, ये बेटर।
It's a request, kindly mute yourself. All the participants kindly mute yourself. It's a request. All the participants kindly mute yourself.
होना थी इधर मीटिंग, एग्जाम सेलिब्रेट।
ನಾನು ದೋಸ್ತ ಬಂದಿದ್ದ ಹೋಗಿ
Good afternoon, everyone. I, Deepika Singh, on behalf of ISC University, welcome you all in one-day national webinar on an introduction to Indian intellectual property rights in India. Today, we will start our webinar with the prayer. I will ask to play the prayer.
जन शुभ युग मंगल किरणों की छवि मांग रहा तुमसे कण कण उतरो 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 तम पथ पर ज्योति चरण उतरो 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 मानव संस्कृति के सुमन किए जनमानस की लहरी कर ले पावन ज्योत्सना का पुण्य वरण उतरो 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 ज्योति करण उतरो 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 छिपे यही यमुना तट पर मोहन भरते मुरली का स्वर दोनवल जग को जिससे अणु अणु आलोकित मोक्ष क्षण उतरो 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 तम पथ पर ज्योति चरण उतरो 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 तम पथ पर ज्योति चरण उतरो उतरो उतरो
Thank you so much. Now, I would like to invite Dr. Devendra Mohan, Pro Vice Chancellor, Institute of Advanced Studies in Education, Deemed to be University, Sardar Shahar, for welcome address. Please, sir.
On behalf of ISC deemed to be University, Sardar Shahar, I, Devendra Mohan, welcome you all in one-day national webinar on an introduction to intellectual property right in India. It is recognized that 21st century belongs to the era of knowledge, economy, and the role of intellect. Any country's ability to translate knowledge into innovation and then commercialize it determine its future. Therefore, issues of generation, evaluation, protection, and exploitation of the intellectual property has become critically important all over the world. Policymakers around the world are laying great emphasis on creating robust intellectual property regime and an ecosystem that encourages innovations. ISC deemed to be university recognizes importance of intellectual property right for the development of the economy and committed to ensure the protection and encouragement of the intellectual property. Considering that 80% of the patent filling in India is by non-resident Indians and others, the challenges before the country is to scale up the process of intellectual property creation and increase commercialization of the technology that is developed. In India, intellectual property right is recognized under various acts, which you will listen by our
रिकॉर्डिंग कर लेना तो हम सुन लेंगे फिर बाद में है ना वो काम की चीज है
to boost up the intellectual property creation among the academician. Today we will listen the three eminent speakers who will introduce the right and laws related to the intellectual property right in India. Thank you.
Thank you so much, sir. Now, I would like to invite Professor K. Rani Lakshmi, Webinar Director, to introduce the theme of the webinar.
Thank you, sir. With this introduction,
topics to be covered by the speakers today: meaning, nature, scope and importance of intellectual property, overview of patent law, patentability criteria, copyright and plagiarism, new dimensions in IPR in India, 2016 modification. And at the last, infringement of intellectual property rights. We will be stay home, stay home, and stay connected with this IPR program.
Thank you so much, ma'am. Today, I got a golden opportunity to introduce the three eminent speakers of the day. Our keynote speaker, Advocate Himanshu Upadhyay, is a known name in his field. Sharing his professional affiliation will take a whole session. So, to brief, he has membership of Delhi Bar Council and Supreme Court Bar Association since 1997. He is a gold medalist for his academic achievements and achievements in practicing the law. It is our pleasure that today we will listen to him and got an unforgettable experience of the same. He will be our speaker for the first section. Welcome you, sir, and thank you for joining us. For the second session, Advocate Ramesh Bhojak will take the screen to shower his knowledge on the intellectual property right in India. Presently, he is a legal advisor of Institute of Advanced Studies in Education, Sardar Shah, and the Master Trainer of Basic Teacher Training College, Sardar Shah. He is practicing the law in Rajasthan High Court for more than 2 decades. I welcome you, sir, and thank you for being with us. Our third session will be showered by the knowledge of Advocate Ilyas Khan Chai. He has 21 years of great experience in practicing law and 7 years of experience in practicing law in Rajasthan High Court. He was General Secretary of Rajasthan High Court and elected as President of Sardar Shah Court for 2 times. Thank you for being with us. Today, what we will discuss? Today we will discuss what is the meaning, nature, scope of the intellectual property right in India. What is the patent law? What is the patentability criteria? Because as an academician, we should know that what are our rights? How can we protect and preserve our rights? What is the copyright and plagiarism? How can you use your copyright and how you avoid the plagiarism? In writing, the new innovations are only stated as innovation when it is true, plagiarism free, and when it has the copyright. There are new dimensions in the intellectual property right, which is amended in 2016 for well-being of all the peoples who are in academia. The infringement of intellectual property rights are large, and today we will come to know about all this with our eminent speakers. Now, I would like to hand over the screen to Advocate Himanshu Upadhyay. Sir. I would like to call Advocate Himanshu Upadhyay to join the screen.
Yes.
Thank you so much, sir.
Good evening, everybody. Today we are discussing about a very interesting topic altogether. It's an intellectual property right. Intellectual property right as a concept was originally designed to cover ownership of literary, artistic work inventions like patent and trademark.
ठीक है कि जब अपन कर गए हैं
Hello, can you hear me now?
Yes, sir.
Can you hear me now? I'm sorry for that. The
Yes, sir.
session was started, and today we are having a very good conference on intellectual property right. Intellectual property as a concept was originally designed to cover an ownership of literary and artistic work, inventions like patent and trademark. In other words, intellectual property rights are intangible in nature, different from the object they are embodied in. The division of the property as a movable and immovable, if it is tangible, as known in Roman law, and now it has been adopted by the modern civil code. Intellectual property is a section of laws which protect the evacuation of the mind and deals with intellectual creations. It is indeed a concept which was originally designed to cover ownership of literary and artistic work, invention like patents and trademark. Therefore, the protection form of work, invention, and relationship between the symbol and a business is intellectual property. It denotes product of mind and intellects which has a capacity of commercial exploitation. If we can say it in nutshell, intellectual property relates to knowledge and information which can be incorporated in tangible object and can be commercially exploited. This is very important, which can be commercially exploited by giving uses on holder of right or over such property. We have generally seen that there are a property which is in physical shape. This is not that property. This is the property which we are creating, and we are creating for the benefit of the people. So intellectual property right is a collective terms used for the independent IP right of first invention. You all know what is called invention. Original creative work, which I think all of you are doing, like teaching, writing some contents, industrial design, and symbol names, which is in trademark, images, geographical indication, etc. There is an intellectual property in mere ideas. If you are thinking that if I go for an idea, fact, event, or discovery, it is not at all a intellectual property. The protection under the IPR law is governed only to particular expression of ideas which fall under legally recognized branch as indicated in Trademark Act, Section 2 and 3, and the Copyright Act, and trade, the patent laws. Intellectual property is a property right and hence can be inherited. It means you can confer the right of the intellectual property, the hence can be inherited, brought. You can buy this. This can be gifted. You can license it, and you can assign or mortgage the intellectual property. So intellectual property laws are only territorial in nature and apply only within the particular jurisdiction. There is no universal law as IPR. Hence, the creators and inventors of various kind of IP need to secure to enforce the IPR in their respective jurisdiction. Wants to right of my IPR by way of trademark, patent, or copyright. If anybody infringes my right, which is protected by virtue of this enactment of trademark, copyright, or patent, then the same person can approach the territorial jurisdiction of the court. So this have a very, very big influence in the act. IPR in the respective jurisdiction as per the respective national laws. It means if we are governed by the Patent Act 1970, we are governed by the Copyright Act 1957. The scope of the protection depends upon the statute of the said country. I would like to add herein that there are international instruments as IPR, including Paris Convention, Bern Convention, and TRIPS. Hello. 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 Sir, if you have missed something. Hello. Hello. Am I audible?
Yes, sir, you're audible.
Yeah, please. I would like to add herein that international instruments like on IPR like Paris Convention, Bern Convention, and TRIPS. TRIPS I will illustrate when I discuss about the patents. The main purpose of the patent system is to encourage innovation and eventually results in technology and development. There are three types of patent, likewise utility patent, design patent,
patents and copyright,
and plant patents. I will let you know when I finish that patent and copyright. Thereafter, I will discuss your issue. First, listen about that patents. What is patent? What is copyright? Then I will answer your question, or you may be satisfied with my wordings that you understood the proposition of patents and copyright. Patent is a Latin word, came from pater, which means to lay open, to make it available from public inspection. To enjoy exclusive right of innovation, this law has been introduced in India. In the year of 1911, it was a product patent and not a process patent. I will let you know about the product patent and process patent also. If the grant of the patent is governed by Indian Patent Act 1970 and Rule 1972 in India, the patent granted under the Act are operative all over India. This Act This is the present act. This is Indian Patent Act 1917, 1970. The silent feature of the act is extension of product patent of drugs, food, and chemical. Terms of patent is 20 years. It means if you are registering the patent, it have a life of only 20 years. It means after 20 years, the patent will become a free patent. Third is examination on request. There is a procedure for the pre-grant and post-grant opposition, fast track mechanism for disposal of appeal, provision of protection of biodiversity. These are the small points which you have to think over it and have something in your mind, but it is not very important to learn about the patent and copyright. There are so many amendments in that act. Act in 2016 was amended. In 2016, the startup is included, wherein the definition of the startup is that 5 years industry who has completed the 5 years from the date of registration, and the turnover is about 25 crores. And there is amendment in 2019, which is, is procedural in nature. There is an amendment qua section 1A, which mandatorily gives a right that not only original document, but the right to file and scan document of original is sufficient for application of patents. Now we are talking about the product patent and process patent. At the time of, if we see the history of the patents, at the inception in 1911, when the first Patent Act came into force by the English era, then there is only and only a product patent, because the English people wants to take away all the rights. They want to enjoy all the rights of the patent, and the product patent herein means to protect a product. It offers high protection to original inventor to reduce the competition. And second is about the process patent. The process patent protects the process through which manufactures the product. From the definition itself, you can take the difference. One is process, one is product. So if with the after some time that there is an Iyengar committee recommendation, Justice Iyengar has given the recommendation, and thereafter 1970 Act came into force, wherein it was found that apart from product patent, process patent is also necessary. And there is a tremendous scope of generic drugs in India. To look for that, we have also started that process patents in India. And we have seen the results also. Within 20 years, there is a tremendous improvement in generic drugs in India. And India become the largest producer in the world in generic drugs. And thus, process patent is considered as a reason behind this achievement. So initially, when you look into that patent laws, only drugs are the maximum patents in India. Now I will discuss about the procedure. The procedure is very simple. Application under Form 1, you have to apply. There is a provisional specification like process and complete specification, which provides 12 months for that application. There is no extension of time is allowed in that. After that, you have to fill Form 9. Along with the Form 9, you can move an application for early publication to the controller. After publication, pre-grant opposition is invited from the public. Simultaneous request for examination can be made within 48 months. First examination report is furnished within the objective and communicated to the patentee, and there have been reporting within 6 months from the date of communication. Once objections are removed and application you have moved is found in order, the patent is granted under section 43. So what we have derived is, first we have to search for the patent, and second is patent drafting, third is provisional patent filing, fourth is complete patent filing. Provisional first and then complete. Complete means you have to make it out that what innovation and in which manner you have innovated the functioning of the right you are taking from the patent authorities. Convention patent filing, multi-country patent filing. Now after TRIPS, I will illustrate the pre-TRIPS also in the last. After TRIPS, TRIPS is a patent cooperative treaty. It is an international patent laws treaty which provided a unified procedure for filing a patent application to protect inventions in each of the country states. And PTC has now 153 country states like UAE, Belgium, Brazil, China, Germany, UK, Greece, Israel. And on 7th of December 1998, India is also included in that. So therefore, application thereafter can be filed with the National Patent Office of contracting for which the application is national, or where the person is residing, or at the applicant's option with the International Bureau of WIPO in Geneva. So after this treaty, the person have a right to go for the international as well as national periphery to enjoy and have that monopoly of this particular patents. So what can be, it's a very, very peculiar subject now. I'm discussing about what can be protected by way of patents. There is no definition or list provided in the enactment that these are the products which can be patented in India. But certainly there are other provisions like section 3 and 4 of Indian Patent Act 1970, which specifically state that which is excluded to what can be patented in India. It means they have given the negative list. Negative list includes discovery is not a patentable. It means a scientist who says that there is law of gravity, he cannot claim the discovery under the Patent Act. Any method of agriculture, process of medicine, surgical is not patentable. There is not any definite list as to what can be patent in India, but certainly it is a negative list which I have just illustrated to you. It has admittedly certain criteria that are required to be met in order to make an invention patentable. Hence, the patentable of invention is determined by the ability to meet the criteria. First of all, criteria is one have to understand the meaning of section 2 1J of the Patent Act, which provides the meaning of the words invention, which is a very important word for this patent law. Invention, according to the Act, means a new product or process involving an inception step and capable of industrial application. From this definition, you can split this definition into two forms. First is invention means a new product. First, invention means a new product, and the new product or process involving an incentive step. It means it should be a new product altogether, and the product involving is of inventive step. And there is a third requirement, that these two requirements are to be added with, that this should be utilized by the society. It means and capable of industrial application. If you are applying for any patent which cannot be utilized for the society at large or industrial application, that patent cannot be granted to you. So this definition is of large implication, and I think for the entire Patent Act 1970, one have to understand this particular wordings of section 21J. I once again say you to read that: invention of a new product. Second is the process involving an inventive step. And third is capable of industrial application. It is therefore construed from the definition under section 2J and reading of section 3 and 4, which I showed you earlier, that 3 and 4 talks about that which are not be, there are certain points for which patent cannot be granted, like discovery, any method of agriculture process, medicine, and surgical is not patentable. So that is in section 3 and 4. That the invention which does not fall under section 3 and 4 satisfied for registration under the Patent Act. Furthermore, the invention must be novelty. I told you along with the application that it's a new idea altogether, a new invention. The invention must be a novelty or new invention as provided in section 2(1) of the Patent Act. Inventive steps as provided under section 2JA of Patents Act. And third and most thing I told you, that it must be of industrial application, or the patent can be utilized by the society at large. Now, novelty or new invention simply means an invention should never be published in public domain or does not form the part of the state of art. Whereas the inventive steps or non-obviousness means that the invention must not be obvious to a person skilled in the same field as the invention relates to. It must be inventive and non-obvious to the person skilled in same form. It is also necessary that invention is capable of being made or used in the industry. Lastly, the patent draft specification must disclose the invention. It is not only invention for the person, but it should be disclosed in writing when you are applying to the registrar, that this is the procedure and how I invented this. Now, an interesting judgment I would like to cite herein. I would like to. I'm hearing some voice, I think. There is a judgment of Novartis versus Union of India. It's a very fantastic judgment. Novartis is a company which have some patents in India and abroad. And it generally files the patent after expiry of 20 years, after some changes in that. Now, the Supreme Court says that the petitioner failed to meet out the requirement of novelty. Because first, there is no innovation of new drug. Mere discovery of existing drug would not amount to invention. So evergreening of patent is not legal in law, because I told you earlier in my discussion that the life of a patent is of 20 years only. After this, you have to renew that patent not in the same manner, like same manner means if you are changing some of the parts of the invention and say that it is altogether a new invention, the Supreme Court says that no, you cannot do this. Secondly, in this judgment, it is held that the grant of pharmaceutical patents, apart from providing the traditional test of novelty, need inventive step and application. It means the law and the technicality should be come together when you apply your mind and say that it is a new thing, it is a novelty, it is altogether a right which is given to you. Because you know, patent is a monopolistic right given to a person who invented it. And the background of the law is very much clear. The law says that one who has done invention or who has done innovation, his rights should be secured till 20 years. After 20 years, it should be in public domain to utilize that public particular right. There is another judgment of Vishwanath Prasad Radhesham versus Hindustan Metal Industries, which illustrate that the object enumerated of the patent is to encourage the research, development, and innovative steps. Slight addition of existing product would not constitute a new product. This is being held in Ravi Kamal Bakshi versus Kalatek judgment. So the patent right is given for a person who have done innovative things, and that particular innovation must be utilized by public at large or by the industry. So if somebody encroach upon your right when you have registered your patent and somebody wants to infringe your right or take away your right, there is a provision under the law to take the remedy against this infringement. For the infringement of Patent Law Act, the aggrieved person can approach the court by filing an interim injunction. Interim injunction means as a measure of interim protection. Whenever you file the petition along with the interim application, you say that immediately I have a danger that I have a right of particular property in this IPR, and the person can infringe your right or take away your right. So you move an application to the court, and court grants a interim protection, which is called interim injunction. Secondly, you can, along with that petition, ask for the damages on account of the profit he has incurred. And third one is permanent injunction. Permanent injunction means he who has infringed your right can be restrained by the court to say that he cannot be able to utilize the monopolistic right given to you by this patent laws 1970. Under section 104 of the act provides that infringement cannot be instituted any court inferior to district court having jurisdiction to try the suit than the high court. It means for this infringement, you can have two remedies available, one to go to the high court and one to go to the district court. Because nowadays there is a law, and law demarcates on the basis of the pecuniary jurisdiction. Pecuniary jurisdiction means when the amount of the claim is involved in the matter. If you have a claim of less than 2 crores, then automatically in Delhi, especially, it will go to the court of district court. Wherever in Rajasthan and other places, the district court have absolute jurisdiction, absolute pecuniary jurisdiction to entertain and try the suit. That term of patent, as already communicated to you, the term of patent is 20 years from the date of filing the patent application, irrespective of whether it is filed within the provision or complete specification. In case the application filed under the patent cooperative treaty that I had communicated to you, that after treaty, we can file here in India also, we can file here, there in Geneva also, or we can file a composite application under the PTC. The term of the patent is always 20 years, but the difference is in the start of the time and completion of the time. In domestic use, it is from the date of filing the present application, and whereas with the PTC, the time starts from the priority date. Wherever in particular act, in this patent act, there is a specific provision that the invention which are prejudice to the human, animal, plant, and environment are not patentable in India. Now, the second chapter is about the Copyright Act 1957. The It's a second right of IPR. The act is applicable in India from 1st January 1958. The act grants bundle of rights to the creator, including right to reproduction, communication, and translation of work. The work which is protected under the copyright is artistic work that includes painting, sculpture, drawing, including diagram, map, chart, etc. Second is musical work. Musical work is, you can divide into two parts: sound recording, cinematography. In the sound also, you can have two parts: the lyrics portion as the sound. Third is about the photography. Photography is also protected under the Copyright Act. Fourth is work of architecture. If a design has been drafted by the architecture, it is also being protected by Copyright Act. Fifth is very important for you all, that is literary work. This literary work includes computer program, database compilation, and sixth is dramatic work like play, music, drama, news. However, it is clear from the act that a copyright protects the expression and not the idea. Further, the copyright does not originally protect titles by themselves or name, short word combination, slogan, short phrases, methods, plots, or factual information. If somebody wants to say that I have a right over the name or short word combination or any slogan which is there in the society or the short phrase, he cannot go for the registration of copyright for these. It is important to note that 107 of the Copyright Act provides the statutory framework of determining the activity which may qualify as a fair use. Fair use means you can use it. Even if the copyright is not in your favor, you can use it. What is fair use? Fair use is criticism, comments, news reporting, teaching, scholarship, etc. The factor of fair use is purpose and character of your use, the nature of copyright work, amount and substantially of the portion taken effective of use upon the potential market. Now, what is the use and duration of copyright? In the patent, we have read about that the term of the patent is of 20 years and the term of the copyright is of 60 years. In case of literary, dramatic, musical, artistic work, the duration and the term of the copyright is lifetime of artist or author and 60 years counted from the year from the following date of the author, death of the author. However, from the cinematography, film, sound recording, and publication, the term of copyright is 60 years from the date of publication. Now, there are three forms for the copyright. Copyright is registered and granted by the copyright registrar. There is a copyright board also, wherein the dispute is to be decided. What kind of dispute are decided as whether work have been published, earlier. If the work had been published earlier, then no copyright can be granted to the person. Second is publication. A writer settled the dispute of assignment of the copyrights under section 19A and compulsory grant license to the unpublished Indian work. And the next is to determine royalty payable to the owner of the policy right. It means if anybody have a dispute about the copyright, then the reference of how much royalty is to be payable to him is to be determined by the copyright board. And in the last, to ratify the register on the application of registrar of copyright. Now there is one copyright society. The constitution of society is a voluntary association of the copyright, which is legally registered in the Copyright Act. For the constitution of copyright society, there is three mandatory conditions. One condition is the necessary registration. Second is 7 owners of copyright should be there. And third is central government approval. What the Copyright Society does? Copyright Society issue licenses, collect fee, agreement with the foreign society, and distribution of fee. Now, one of the most important features I am telling you that registration of copyright is not mandatory, as registration is treated as a major record of fact. However, as a proof of ownership in the court and to act upon smoothly, it is required to be registered. So in India, there is no mandatory provision for registration of content of copyright. But if you want that tomorrow your copyright is infringed or your right have been taken away by the third party, then automatically you have to show to the court that look here, this is the right which is given to me by the Copyright Society, by the copyright registrar. So infringement of that particular right is prohibited. The person who got the copyright can utilize the same. Otherwise, it would be considered as a violation of infringement of copyright, for which again you can file the same provisions as in the patent interim injunction, that you are saying to the court specifically by filing a petition that immediately stop the other person from infringement of their right. Secondly, damages or account of proof. You can ask for the damages from the person who is infringing your right of copyright. Third is permanent injunction, which is always hold when the matter is decided. So copyright infringement is civil as well as criminal punishments. Civil, you have already heard that you can grant, you can move for the temporary injunction, permanent injunction, and you can ask for the money. Even otherwise, also in criminal law, infringement of copyright is an offense. Offense cognizable in nature and punishable for a term of not less than 6 months. Copyright Act gives power to the public authorities to register, complain, FIR, and on its own to arrest the accused, search the premises of the accused, and seize the infringement material without intervention of the court. But for the second offense by the person, there is a provision of enhanced fine in the statute. This is altogether the two laws which we have now discussed. First is about the patent, second is about the copyright. Now, I am giving you one case study about the copyright. You know, in Delhi University, there was a photocopy shop which provides reading material prescribed for the test book and sell to the students. Case was filed against him for infringement of copyright by the University of Oxford under Section 2(0) of the Copyright Act. The court's observation is, very fantastic. Copyright is not a divine right. It is intended to increase the harvest of knowledge, not impede it. Photocopy of the with the objective of spreading knowledge and fastening education does not violate the copyright laws, or it cannot be construed as copyright infringement. Publication withdraw the publisher who has filed this petition, he withdraws the legal suit during the hearing, and it was observed that shop land is legal license to operate with the North Campus premises of Delhi University. It clearly reflects one line that if you are using that particular right for your purposes, for reading the things or for generating your knowledge, without, it cannot be construed as an infringement of copyright. But if you are doing any commercial activity with the copyright, then it should be punishable under the criminal code as well as under the civil code, as I illustrated to you. So these are my lecture for you, and I request madam.
Yes, sir. I can hear you.
Madam, Madam, I have given the background of the IPR in India.
Yeah.
Thereafter, I started with the patent laws 1970, the starting of patent laws in India in 1911. Thereafter, starting of the copyright infringement, patent infringement, and one case study of both. So I would like.
I'm there with you. I know that you have elaborated so well, and our speakers get benefited with it. Sir, if it is you permit, then can we ask 4 or 5 questions if
Please,
participants?
Please, madam. Please, madam.
It is a request to all the participants to kindly raise your hand who want to ask question to the sir. Kindly make it fast so that we can move to the another session. जिनको भी प्रश्न पूछना है वो कृपया अपने Zoom ऐप पे अपने hands raise करें so that they can ask the question, ताकि वो question पूछ सकें. Once you raise the hand, we will unmute you so that you can ask the question. Yeah, we have one participant, sir, who want to ask the question to you.
He is most welcome.
Yeah.
Most welcome, gentlemen.
Yeah, sure, sir. Mitesh Chaudhary, kindly ask the question, sir. Sir, kindly unmute yourself and ask the question. Mitesh Chaudhary, can you hear me? Yeah, sir, please ask the question.
Madam, call for the another speaker. Thereafter, you can ask the question in the last also, because it will save your time also.
Yeah, sure, sir. Sure, sir. Please, sir.
I'm there online. If you can ask any question, I am ready to reply that.
Thank you. It is a great pleasure to hear, sir. Now, I would like to invite Advocate Ramesh Bhojia to shower us with his knowledge. Sir, kindly take the seat.
आज की इस कॉन्फ्रेंस में मैं आप सभी का स्वागत करता हूं। बौद्धिक संपदा अधिकार विषय पे ये कॉन्फ्रेंस जो है आयोजित की गई है। वेबिनार कोरोना की वजह से वेबिनार ही आजकल आयोजित की जा रही है। हम जानते हैं कि मस्तिष्क का विकास जो है सभी लोगों का एक समान नहीं होता। कुछ लोगों का मस्तिष्क का विकास जो है वो अधिक होता है और कुछ का कम होता है। मस्तिष्क का विकास जो है वो किसी उम्र, स्थान या किसी विशेष परिस्थितियों पर डिपेंड नहीं करता। मस्तिष्क का विकास जो है वो एक ईश्वर की देन होती है। किसी व्यक्ति का छोटी उम्र में भी मस्तिष्क जो है बहुत अच्छा काम करता है और किसी का बड़ी उम्र तक की मस्तिष्क का विकास जो है नहीं होता। मैं आपको बता दूं कि एपीजे अब्दुल कलाम जो थे, उनके मस्तिष्क का विकास जो है बड़ी निर्धनता के बीच भी बहुत शानदार हुआ और उन्होंने जो काम किया वो शायद दूसरा व्यक्ति जो है वो नहीं कर पाता, यदि वो संपन्न भी था तब भी नहीं कर पाता। इसलिए मस्तिष्क का विकास जो है स्थान, परिस्थिति या किसी उम्र का मोहताज नहीं होता है, वो अपने हिसाब से ही और अपनी क्वालिटी, अपने ईश्वर की दी हुई क्वालिटी के आधार पे वो सारा कुछ होता है। एक विकसित मस्तिष्क के व्यक्ति के दिमाग में बहुत कुछ नया करने की चाहत रहती है, किसी समस्या को आम लोगों से अलग ढंग से सोचता है और वो कुछ करने की अपनी उपयोगिता रखता है। उसको यदि अवसर दिया जाए तो कुछ ऐसा आविष्कार या कोई काम जो है वो कर देता है, ताकि आने वाली पीढ़ी जो है वो उसे बहुत कुछ हासिल कर सकती है। मैं आपको बता दूं कि रामायण और महाभारत का अभी कोरोना में उपयोग किया गया। उस रामायण और महाभारत के सीरियल को रामानंद सागर ने बहुत ही शानदार तरीके से पर्दे पे उभारा और उस रामायण या महाभारत के एपिसोड के लिए आज भी उनके परिवार को भारत सरकार ने 25,000 रुपये पर एपिसोड के देने तय किए थे। उन्होंने नहीं लिया, ये उनका बड़पन है, लेकिन वो रॉयल्टी जो है उनके परिवार को लगभग 50 साल तक प्राप्त होती रहेगी। इसी प्रकार जो है बहुत से ऐसे प्रोडक्ट है जिनका आविष्कार हुआ, उनका रजिस्ट्रेशन करवाया गया, उनका पेटेंट करवाया गया। जैसे एटलस साइकिल है, टाटा का प्रोडक्ट है, तो उन सब का जो है आविष्कार किसी व्यक्ति विशेष द्वारा किया गया और उन्होंने उस आविष्कार के लिए अपना राइट्स का कायम रहे, उनकी बनाई हुई चीज का उनको फायदा मिले, उनके दिमाग का उनको फायदा मिले, किसी अन्य व्यक्ति को उस चीज का नाजायज फायदा नहीं उठा पाए। इसलिए उन्होंने अपने हिसाब से, अपने तरीके से और भारत सरकार द्वारा दी गई सुविधाओं का फायदा लेते हुए पेटेंट्स राइट्स करवाए। ये एक तरह का व्यक्ति विशेष के लिए अच्छा अवसर है कि वो अपने बौद्धिक संपदा को अधिक से अधिक लोगों के बीच में पहुंचा सके, ताकि देश के विकास में काम आए, सामाजिक विकास में काम आए और आर्थिक विकास में काम आए। मैं आपको बता दूं, किसी व्यक्ति के पास कुछ नहीं है लेकिन उसके पास आवाज, जैसे लता मंगेशकर के पास अपनी आवाज, मोहम्मद रफी के पास अपनी आवाज थी, मुकेश के पास अपनी आवाज थी, किशोर कुमार के पास अपनी आवाज थी, तो उन्होंने जो गीत गाए वो गीत अमर है और उन आवाज के लिए भी उनको पारिश्रमिक के तौर पे उनके आवाज के लिए उनको भारत सरकार द्वारा एक रॉयल्टी दी जाती है और उनका पेटेंट जो है राइट किया। इसी प्रकार किसी लेखक ने यदि कोई किताब लिखी है, कोई काव्य संग्रह लिखा है, कोई और लिखा है, तो अपना पेटेंट राइट करवा सकता है। अपने द्वारा किए गए आविष्कार का कोई व्यक्ति जो है, यदि वो नया है, हिंदुस्तान के किसी काम का है, तो उसका यदि वो कहीं भी उपयोग करें तो उसके लिए वो पेटेंट राइट करवा सकता है। मैं आपको बता दूं कि आज भी अमिताभ बच्चन की आवाज़ जो है वो पेटेंट राइट में, लता मंगेशकर की आवाज़ जो है वो पेटेंट राइट में, उनका कोई कॉपीराइट नहीं कर सकता, उनकी कॉपी जो है वो कोई भी व्यक्ति नहीं कर सकता। कॉपीराइट के लिए या किसी भी इस एक्ट के जितने भी ट्रेडमार्क, सिंबल्स जो भी है, उनको यदि हम अपने अधिकार क्षेत्र में रखना चाहते हैं तो उनका कॉपीराइट करवाना पड़ता है और उस कॉपीराइट के लिए एक विशेष प्रक्रिया है, उस प्रक्रिया से हम जो है उनका कॉपीराइट करवा सकते हैं। कॉपीराइट, ट्रेडमार्क, पेटेंट, इंडस्ट्रियल डिजाइन, ट्रेड सीक्रेट्स या भौगोलिक संख्या जो भी, उनका हम जो है कॉपीराइट करवा सकते हैं। कुछ चीजें जो है भौगोलिक परिस्थिति, भौगोलिक स्थान के आधार पे जानी जाती है। जैसे हमारे यहाँ राजस्थान में भुजिया बनते हैं और वो बीकानेर के प्रसिद्ध है और बीकानेर के भुजिया का कॉपीराइट करवाया जा सकता है। इस प्रकार से बहुत सी ऐसी चीजें जो व्यक्ति विशेष की खुद की होती है, उसमें किसी समाज या किसी व्यक्ति का योगदान नहीं होता। वो व्यक्ति जो है अपने दिमाग से उसका आविष्कार करता है और उस आविष्कार के लिए उसको प्रतिफल मिलता रहे, इसके लिए सारे कानून बनाए गए हैं। इस कानून में समय समय पे अमेंडमेंट भी होते रहते हैं। इसलिए कोई भी व्यक्ति जो है अपने मस्तिष्क के विकास का सामाजिक या समाज हित में उपयोग करना चाहें तो उसको सुरक्षित करने के लिए इस तरह के कानून जो है वो भारत सरकार ने बना रखे हैं। ये भारत सरकार और अब्रॉड तक काम आते हैं। कोई भी आविष्कार, किसी की आवाज, किसी का काव्य संग्रह, किसी की रचना, वो जो है इस कानून से सुरक्षित है। धन्यवाद।
Thank you, sir. Now, I like to invite Advocate Ilyas Khan Chai. Thank you, sir. Now, I like to invite Advocate Ilyas Khan Chai for the third session. Thank you, sir.
Thank you, madam. गुड आफ्टरनून। आज जो ये वेबिनार रखा गया है इंटेलेक्चुअल प्रॉपर्टी पे, इसके बारे में पूर्व सीनियर एडवोकेट उपाध्याय जी मौजक साहब उन्होंने आपको बताया। इंटेलेक्चुअल प्रॉपर्टी, जिसका हिंदी शाब्दिक अर्थ है बौद्धिक संपदा। तो बौद्धिक संपदा अपने नाम में ही ये सब कुछ बताता है कि हमारी बुद्धि से जो भी चीज तैयार की है वो हमारी संपदा है। हमारे पास अगर कोई भूमि है, हम उसके टाइटल होल्डर हैं, हमारे पास एक सैंडिड है, हमारे पास एक गाड़ी है, उसकी एक आरसी है अपने पास, तो जो मालिकाना हक है, स्वामित्व है, उसको बताने का पर्पज है कि ये जो डॉक्यूमेंट है, जहां बौद्धिक संपदा सामने अपने आई, तो इसमें जिस भी व्यक्ति के माइंड में ये चीज आई, उसने ये सोचा कि अगर मैं इस चीज को कहीं बाहर लेके जाऊंगा तो हो सकता है लोग इसकी नकल करें, हो सकता है लोग इसका मिसयूज करें या अपने फायदे के लिए काम में लें, तो इसके लिए कानून बनाए जाए। वो व्यक्ति ऐसा सोच के उस चीजों को रोक लेता था। तो कोई भी चीज ऐसी जो एक विकसित दिमाग में आई और लार्ज ऑफ पब्लिक के लिए काम में आने वाली चीज, अगर उसको उस दिमाग तक रोक लिया जाए तो लार्ज ऑफ पब्लिक, पूरे विश्व का जो भला होने है वो संभव नहीं है। इसके लिए क्या किया जाए? ने इसके लिए अलग अलग कानून बनाए। सब आप अगर अपना जो आविष्कार कर रहे हैं, आपके माइंड में जो थॉट है, आपकी जो बौद्धिक संपदा है, इसके आप 100% आप बेनिफिशियरी रहे, आपको इसका फायदा मिले और इसका कोई दुरुपयोग न करे, तो इन्होंने अलग अलग उसके लिए कानून बनाए। जो कानून के अंतर्गत कॉपीराइट बना दिया, पेटेंट लॉ बना दिया, ट्रेडमार्क बना दिया, भौगोलिक स्थितियों के हिसाब से अगर कोई चीज वहां की है तो उस पे कानून बना दिया। ये कानून बनाने का उद्देश्य जो था वो ये उद्देश्य है कि जिस भी मस्तिष्क में जो चीज आविष्कार के रूप में, रचना के रूप में, सिंबल के रूप में, चिन्ह के रूप में, प्रतीक के रूप में, संगीत के रूप में, गीत के रूप में, जिस भी रूप में एक डेवलपमेंट के रूप में आई, उसका प्रोटेक्शन किया जाए। ये उद्देश्य इन कानूनों का है। मुख्यतः जो कानून बने हुए हैं उसमें कॉपीराइट में क्या क्या चीजें कवर होती है, कैसे कैसे होती है कि मान लीजिए किसी ने कोई रिटर्न, जैसे कोई कवि है, उसने अपनी एक रचना लिखी है या ऐसा कोई निर्माण किया है जो लिखित में आ रहा है, और जिस दिन वो लिखित में आया उससे पूर्व उसका निर्माण कभी नहीं हुआ, न देखा गया, न सुना गया, ऐसी चीज को कॉपीराइट के अंतर्गत कॉपी कराने का अधिकार उस व्यक्ति को है। कॉपीराइट के अंतर्गत उस व्यक्ति को अगर वो अपने राइट को ये कहते हुए कि साहब ये जो रचना है ये मेरी बनाई हुई है, इससे पहले इसका निर्माण नहीं हुआ है, तो 50 वर्ष के लिए वो उस चीज को कॉपीराइट करवा सकता है। 50 वर्ष तक उस चीज को, उस रचना को कोई अन्य व्यक्ति उसके बेनिफिशियरी उपयोग में, मान लीजिए एक कवि ने कोई कविता लिखी, उस कविता को आप गुनगुना सकते हैं, परंतु अगर उसका बेनिफिट लेने के लिए आपने उस रचना का प्रयोग किया तो आप प्रोहिबिटेड, आपको रोका जाएगा, क्योंकि उस रचना का निर्माण जिस व्यक्ति ने किया है वो व्यक्ति ही बेनिफिशियरी के रूप में, लाभार्थी के रूप में वो व्यक्ति ही आएगा और वो व्यक्ति लाभार्थी बनेगा उसका। इसके लिए अगर ऐसी कोई रचना है, ऐसी कोई चीज है जिसका पूर्व में ऐसा उपयोग नहीं हुआ है या नहीं आई है, तो आप उसका कॉपीराइट के अंतर्गत अपना रजिस्ट्रेशन करवा सकते हैं। दिल्ली में इसका जो कॉपीराइट जो आपको करवाना है, जिसमें उसका मुख्यालय में जाके कॉपीराइट का जो ऑफिस है उसमें जाके आप कॉपीराइट को अपने संबंधित विभाग से कि ये सब मेरी रचना है, इस तरह से ये मैंने किया है, तो वो कॉपीराइट होगा और उसका बेनिफिट किसी अन्य व्यक्ति को नहीं दिया जाएगा। वो बेनिफिट हमेशा 50 वर्ष तक के लिए आपको मिलता रहेगा। इसके अलावा आता है ट्रेडमार्क। ट्रेडमार्क में ऐसा कोई चिन्ह, ऐसा कोई प्रतीक, ऐसा कोई सिंबल जो आपके प्रोडक्ट पे लगा हुआ है और उस सिंबल से आपके प्रोडक्ट की पहचान है, तो आप उस सिंबल को ट्रेडमार्क में 2500 रुपये मात्र देके उस सिंबल को आप 20 वर्ष के लिए रजिस्ट्रेशन करवा सकते हैं और बस 20 वर्ष के बाद, प्रत्येक 5 वर्ष के बाद आप उसका नवीनीकरण करवाते रहेंगे। तो जब तक आपका नवीनीकरण रहेगा, कानून ये है कि जब तक आपका नवीनीकरण रहेगा तब तक उस ट्रेड को, उस प्रतीक चिन्ह को किसी भी अन्य व्यक्ति को यूज करने का कोई अधिकार कतई नहीं है। इसी चैनल में चलते हैं हम, तो आगे आपके सामने आएगा पेटेंट लॉ। पेटेंट लॉ में क्या आएगा? पेटेंट लॉ में वो चीजें जो आपके मस्तिष्क से निकली और जिसने आविष्कार का रूप लिया, और आविष्कार का रूप लेने के बाद वो जो चीज है वो लार्ज ऑफ पब्लिक के काम में आने वाली है, और ऐसा आपको अंदेशा है कि ऐसी जो चीजें हैं वो किसी अन्य व्यक्ति द्वारा काम में ली जा सकती है, तो आप अपनी उस आविष्कार को सुरक्षित रखने के लिए आप उसको पेटेंट करवा सकते हैं। पेटेंट के अंतर्गत ये जरूरी नहीं है। पेटेंट कानून में एक सबसे बड़ी बात, ये बहुत अच्छी चीज आई है कि जो भी चीज आपको पेटेंट करनी है उसका आप विवरण दे सकते हैं कि साहब मैं ऐसी चीज या तो निर्माण कर चुका हूं या निर्माण की प्रक्रिया में हूं, और वो जो निर्माण की प्रक्रिया है वो फाइनलाइज, उसका एक रूप लेगी, वो ये रूप लेगी, तो उस रूप, दोनों ही रूप में आप अपनी उस चीज को एक पेटेंट लॉ के अंतर्गत आप पेटेंट करवा सकते हैं। और पेटेंट करवाने के बाद में पेटेंट का जो लाभ है वो आपको 20 वर्ष तक, इसमें ये ध्यान देने वाली बात है, कॉपीराइट और ट्रेडमार्क वहां चीजें अलग है, वहां 50 वर्ष तक है और ट्रेडमार्क में 20 वर्ष तक है। 20 वर्ष के बाद 5 वर्ष तक आपको पंजीयन करवाना होता है, लेकिन पेटेंट लॉ में आपको एक रोक, चेक लगा है कि आप 20 वर्ष तक है उस चीजों को आप अपने आविष्कार को पेटेंट करवा सकते हैं। अब ये जो सारी चीजें पैदा की गई, ये इसलिए पैदा की गई कि कोई भी चीज है, आज उस चीज को बनाने में या उस आविष्कार को करने में जो दिमाग, जो मस्तिष्क का पावर लगता है, आविष्कारों में कई ऐसे आविष्कार भी हैं जिनमें आर्थिक भी चीजें चाहिए, पैसा भी खर्च होता है। अब वो चीजें कोई एक व्यक्ति खर्च करता है और बनी हुई तैयार चीज के लिए का उपयोग दूसरे लोग नकल करके करने लग जाते हैं, तो इससे जिस व्यक्ति ने अपनी बुद्धि, अपना पैसा, अपना समय जो व्यतीत किया, वो उसका लाभ उसी को मिले। कोई अन्य व्यक्ति है वो उसका लाभ नहीं ले, सिर्फ नकल करने के माध्यम से। तो ये चीजें, इनको चेक मार्क करने के लिए ये जो कानून है ये सारे बनाए गए। अगर आपकी कोई चीज कॉपीराइट है, कोई चीज पेटेंट है, कोई चीज ट्रेडमार्क में आती है और उसका आपको कहीं भी ऐसा अंदेशा लगता है कि साहब ये जो चीजें हैं इनका गलत रूप से कोई एक्स व्यक्ति उपयोग ले रहा है, तो आपको ये अधिकार है कि आप संबंधित कोर्ट में इंजेक्शन मैटर, इंग्लिश में इंजेक्शन मैटर कह सकते हैं आप, हिंदी में आप इसको स्टे मैटर कह सकते हैं। आप उस व्यक्ति के विरुद्ध, यूज करने वाले व्यक्ति के विरुद्ध, मिसयूज करने वाले व्यक्ति के विरुद्ध न्यायालय में जा सकते हैं और उसको स्टे मैटर के द्वारा उसको मैटर को स्टे करवा सकते हैं। और जो यूज उसके द्वारा किया गया है उसके बदले, जो यूज किया उसके बदले, या तो आपको जो नुकसान, जो दर्शित नुकसान है कि साहब इतना नुकसान मुझे इस यूज से हुआ है, उस दर्शित नुकसान का आप नुकसान ले सकते हैं न्यायालय के माध्यम से। या एक कोई आइडियल कि साहब ये जो नुकसान है ये लगभग ये होता है जिसको कोर्ट तय कर देता है कि वास्तव में जो नुकसान हुआ है वो आपको ये इतना हुआ है और इससे ये दर्शित होता है, वो नुकसान ये आप उसके विरुद्ध ले सकते हैं। और आईपीसी में दंडात्मक जो कार्रवाई है वो उसके विरुद्ध दर्ज कर सकते हैं। आप सीधे पुलिस थाना में जाके उसके विरुद्ध एफआईआर दर्ज करवा सकते हैं। एफआईआर दर्ज अगर पुलिस नहीं करती है तो आपके पास रेमेडी ये है कि आप न्यायालय के माध्यम से आप उस व्यक्ति के विरुद्ध है वो फौजदारी प्रकरण दर्ज करवा सकते हैं। तो जो बौद्धिक संपदा का कंसेप्ट है वो कंसेप्ट निष्कर्ष रूप में ये निकलता है कि व्यक्ति के स्वयं के दिमाग से निकली हुई नई चीजें और उसमें लगा वो समय और परिश्रम, इनका बेनिफिट निश्चित रूप से उसी व्यक्ति को मिले जिस व्यक्ति ने ये सारी चीजें खर्च की। और उन लोगों को चेक करना, उन व्यक्तियों को रोकना जिन व्यक्तियों के द्वारा उसके मिसयूज करने का, उन बनी बनाई चीज की नकल करने का और नकल करके और उसका लाभ लेने का जो प्रयत्न है वो नहीं किया जाए। तो ये जो सारी चीजें हैं जो आपके दिमाग में, अगर आपके दिमाग में भी ऐसी कोई चीज है जो नई है, जो नई बनी हुई पहले, तो ऐसी कोई चीज आप बाहर आती है, तो अगर रचना है तो आप उसको कॉपीराइट में जा सकते हैं। सिंबल, कोई प्रतीक चिन्ह है ऐसा है तो आप उसको ट्रेड में जा सकते हैं। कोई ऐसा आविष्कार है तो आप उसको पेटेंट में जा सकते हैं। पर्टिकुलर ऐसे कोई स्थान पे रहते हैं कि उस स्थान से उस वस्तु का ही निर्माण होता हो तो वो ज्योग्राफिक होता है। तो अगर ऐसी कोई चीजें आती है तो ये आप सारी कॉपीराइट करवा सकते हैं, ट्रेड में जा सकते हैं, पेटेंट में जा सकते हैं। इनमें जाके आप अपने उस प्रोटेक्शन, आप ये ऐसा प्रोटेक्शन ले सकते हैं। और इसमें आपको सबसे बड़ी बात है कि कोई चीज नहीं आई है तो उसमें आपको घबराने की जरूरत नहीं है। इतने सारे कानून है कि उसका बेनिफिट निश्चित रूप से आप स्वयं को मिलेगा। तो लार्ज ऑफ पब्लिक के लिए अगर कोई चीज आपके माइंड में आई है तो उस चीजों को लार्ज ऑफ पब्लिक के लिए उपयोग में लीजिए। जैसे मान लीजिए आज कोई कोरोना की आज दवाई आ जाती है, कोरोना महामारी चल रही है, उसकी कोई दवाई नहीं, उसकी महामारी चल रही है, तो आपके माइंड में अगर आपके पास ऐसी कोई चीज आती है तो ये चीज जो है वो आप अकेले के लिए उपयोगी नहीं, ये लार्ज ऑफ पब्लिक के लिए उपयोगी है। और लार्ज ऑफ पब्लिक के लिए जो चीज उपयोगी है तो उसको आप पेटेंट में जाके और उसका पेटेंट करवा के आप जनता में उसको दे सकते हैं जिससे लोग बेनिफिशियरी होंगे और उस बेनिफिट लोगों को तो होगा और उस आविष्कार से बदले में आपको भी उसका लाभ मिलता रहेगा। तो ये जो सारी चीजें हैं, ये बौद्धिक संपदा है। आपकी बुद्धि के द्वारा जो भी चीजें पैदा हुई है, बुद्धि से आपने जो चीज कमाई है, उस चीजों को सबको आप लार्ज ऑफ पब्लिक के काम में लें। लोगों को उस आविष्कार से, उन रचनाओं से, उनसे उनका जो है, जो आवश्यकताएं हैं वो पूरी हो, वो लाभ मिले। और उसके बदले आपको जो आविष्कार किया है आपने, उसका जो समय व्यतीत किया है, जो पैसे व्यतीत किए हैं, वो आपको वो रॉयल्टी में मिले। धन्यवाद। इस संबंध में जो भी आपके क्वेश्चंस एंड आंसर्स हैं वो आप ले लें। और उपाध्याय जी हैं, भोजक जी हैं और मैं हूँ, जो भी क्वेश्चंस हैं तो कोशिश करेंगे आपके उसके आंसर। नमस्कार।
बहुत बहुत धन्यवाद हमारे तीनों स्पीकर्स का। It is a great pleasure that we have organized in one day national webinar on IPR, and it is a great pleasure to listen to all the three eminent speakers. Now you can ask the questions to our eminent speakers by raising your hands in the chat room so that I can unmute you and you will be able to ask the question. We are here for 10 minutes. You can ask the question. Kindly raise your hand.
Ma'am, what is the difference between patents and copyright?
जिनको भी प्रश्न पूछना है कृपया चैट रूम में अपने हाथ को ऊपर करें ताकि उनको अनम्यूट कर दिया जाए। जिन्होंने क्वेश्चन पूछा है अभी, he is not audible. He or she, I don't know, the name is not there. Please ask this question clearly. Yeah, there is an ID 6JVY2G. Kindly ask the question. Okay, then next is Anshul Gupta. Dr. Anshul Gupta, you can ask the question, sir.
Am I audible?
Yeah, ma'am, you are audible.
Okay. Ma'am, my question is, what is the step for getting patent in trademark? What is the difference between a trademark and a patent thing? And what will be the steps for getting process patent?
Okay. I request Himanshu sir to address this question. Ma'am, you have to wait for 2 minutes. Himanshu sir is with us. He will answer your question.
Okay, ma'am.
Hello. Hello.
Yes, sir, you are audible.
Yeah, please. She has asked a simple question that what is the difference between trademark and patent? Patent is granted for the new innovation wherein there is a novelty first, and you can utilize the particular thing for the commercial purposes like industry and other things. Trademark is for the trade name, trade concept, or words only. This is not altogether a concept. It is only for the words, phrases, or identical names for which a trademark is being applied and being granted by the trademark authorities. Whereas property in the intellectual property right, the patent laws is granted to new innovation, like if you are forming in machines or drugs, which was not in the public domain prior to that. This can be patented as a patent laws. The patent laws require research work, where the trademark is for the innovative things, innovative words, or innovative, subject. Any other things you want?
Ma'am, is your question answered?
Yeah, my second question is, what are the steps for getting process
Your
patent?
voice is not clear now.
Ma'am, you're not audible.
Now I'm audible.
Hello?
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 Am I audible?
No. Yeah, madam. Yeah, tell me.
Yeah, what is the steps for getting process patent?
Process for?
Process patent. Steps for getting process patent.
First of all, you have to check that whether prior to that there is any patent there in the public domain or registered with a registrar. Then only you can apply for that patent. For meeting out that requirement, you have to look into section 3 and 4 of the Patent Act, which provides that these things cannot be patented. Mere idea, you think that it's an only idea, or you think that it is a forming of anything which according to the office of the patent, it is not an innovation altogether. Likewise, I've given the example that Isaac Newton, cannot go for the patent of what he has discovered. Discovery, new ideas, this is not a patent. You have to develop a thing which is novelty, plus second requirement is this can be utilized for industrial purposes. So you have to look into these parameters, and then only you can apply for for the registration of patent.
Thank you so much, sir. Now we have another question from Sanjay. We have another question from Sanjay, sir. Sir, kindly ask the question. Sir, kindly unmute yourself and ask the question.
Am I audible now, ma'am?
Yeah, please.
Ma'am, this is Sanjay from UP. My simple question is from hello.
Yeah, please.
Hello. My question is from sir. Hello.
Hello. Mic on kar do. Sir, kindly ask the question.
Ma'am, there is disturbance. How can I ask the question? Okay, ma'am.
Yeah,
now,
please.
May I raise my question?
Yeah, please.
Okay, ma'am, my question is to the sir that suppose I have created certain article, a certain research paper, then what is the process to get the copyright of the same? I mean process, how can I get the copyright of my article, my research paper, or anything like, or say my chapter or any educational content that I have created, how to get the copyright of the same? What is the process? I have to go to the electronic means, or I have to go to the court, or any other process, any other method?
Office of the Copyright, with your entire details of the content, that this is not in public domain prior to that, and you have to explain that this is your content altogether. This is not an state of art. This is not prior in the domain of this society, and this is all innovative work you have done. Explaining these three things, you can register your copyright with the registrar, or you can take help of the Copyright Society for the registration of your copyright. But you have to disclose the three parameters which I have just explained to you, that this is not in the domain of the society at large prior to your being written. Secondly, it is being written by you only. And thirdly, that this is not an art, prior art of the society. So after complying all these three things, you can apply for the registrar or go for the society, Copyright Society, who can register your contents. But you look here, the society is only registering the copyright of the contents only. They will not give any, copyright of your title or other things. For the title, other things, you have to go for the trademark. There is a separation of, concept of trademark, copyright, and patent. So you have to understand this, and then only you have to go for that registration of copyright before the registrar of copyright in Dwarka, Delhi.
Thank you so much, sir. Is there anyone else who want to ask the question?
हेलो, मेरी आवाज आ रही है?
बिल्कुल जी।
सवाल नहीं है, मुझे तो बस ये कहना है कि आपने इतने अच्छे से समझा दिया है, सारी बातें बता दी हैं। मुझे लगता है कि अब कुछ
Sir, you are not audible.
मैडम वो तो धन्यवाद कर रहे हैं बस खाली, बाकी कुछ नहीं कह रहे हैं। वो तो ही इज सेइंग दैट you have all made us understand about the law, both the laws, so we are thankful for that.
Right. Sir,
Not asking any question from your side.
okay, thank you, sir. Sir, now I would like to invite Dinesh Chandra Maurya, co-coordinator of IQSC, ISC deemed to be University Sardar Shah, to give the vote of thanks. Sir, kindly unmute yourself.
Yes, ma'am.
Yeah, thank you, sir.
Good afternoon to all. It has been our pleasure to host all the participants of the webinar at ISC deemed to be University Sardar Shah. The participants were very keen. I am thankful to all the participants for joining the webinar to attend this IPR program. I am sure that the participants must have benefited by attending this webinar. I am thankful to Advocate Himanshu Upadhyay, Advocate Honorable Supreme Court, for kindly accepting our invitation to be the keynote speaker. I am also thankful to Advocate Ilyas Khan Chail and Advocate Ramesh Bhojak, Advocate Rajasthan High Court, for accepting our invitation to be speaker. I am thankful to all the speakers for the contribution of invaluable knowledge to us. I thank Professor Devendra Mohan Sharma, Pro Vice Chancellor, ISC deemed to be University, for his inspiring mentorship. I am also thankful to ISC administration in general, providing us with all possible logistic support towards organizing this event. My thanks also go to all the people who have given their precious time in organizing, in particular convener Ms. Deepika Singh and webinar director and IPSC coordinator Professor K. Rani Lakshmi for organizing such a wonderful event. I once again thank everyone whose contribution has made this webinar a successful webinar. Thank you very much.
Thank you, sir. On this note, I am ending the meeting. You will get the feedback link in your email. Thank you so much.